Oh, good.
Yeah. Yeah.
Yes, I think we're over on.
Oh, yeah, everything's like it over there.
Out there. Oh. So when you emailed me, that was the case I was reading, that Clark case. And I kept trying to find something different because I wanted a case where they had accepted, but then we rescinded. That case,
Mine's working.
they actually accepted.
Yeah. Sorry about yours. Maybe it's all those screens.
There's a trial.
Good morning. Good morning. Let's get started so we can try to fit everything in this morning that we are hoping to do. I'll get a little update from who we do have here. Is there anyone in the back? Who's in the back? Mr. Shart?
No, the two public defenders look like they're.
Ms. Wood?
This Wood is.
Okay. Hearing an awkward conversation. Hey, Mr. Shark can go back in there. I just need him out here for a second to get an update. Good morning.
Good morning, Judge.
I just wanted to, you can keep your conversation going. I just wanted to figure out what we were going to work through today, this morning. So first out on Monday is Mr. McKinnon and Mr. Russell. So Mr. Shark's client and Ms. Clark's client. Ms. Clark Mr. Russell is here. Is he entering a plea today, or what are we doing with Mr. Russell? Okay. And Mr. Shart, it sounds like you are in the midst of discussions with Mr. McKinnon about how that's going to go.
Mr. McKinnon is entering a plea today.
Okay. Well, that's an assertion.
As I'm glaring at Mr. Abadi,
Okay.
the state has put things on my plate at 11:59, and I'm trying to sort through a few things.
Okay.
So I'm just trying to have some communications with my client so I can, and I also need to have brief communications with Mr. Abadi. We are entering a plea one way or another.
Great. And we will make that happen. And to accommodate the 11:59 arrival of whatever landed on your plate, I'll let you continue to talk with Mr. McKinnon. We'll do Mr. Russell's plea first.
I haven't spoken to him about Mr. Abati's,
We will not do Mr. Russell's plea first. Let's figure out how we're going to work through this. I just wanted to free up Mr. Shart, but if Mr. Abate can't do a plea right away because Mr. Russell's not available, then you can continue to talk to Mr. McKinnon. We need to work through the Landon Christopher situation. Are you Mr. Christopher? So he's here, so we can talk about that maybe while the lawyers for Russell and McKinnon keep talking. And then Mr. Sexton, is that ready to go, Ms. Wood?
Yes, Judge, it'll be non-negotiated, and if we could maybe we will do the Christopher first, but his grandmother is on her way, I believe, Mr. Sexton. So
Okay.
she'll be on the Zoom.
We also need to talk about Mr. Montgomery, so we'll do that early on because Mr. Hood has joined the call. And then we've got an iPhone on that clearly wants to be in the mix, keeps turning the audio on. I don't know who that is. Ma'am, on the iPhone, can you let us know who you are?
I'm Marquise's grandmother, Miss Jenkins.
Got it. I remember meeting you before. So you're connected
Yes.
to the McKinnon and Russell case.
Yes.
Excellent. Well, if you don't mind staying on the call, we are taking, it sounds like we may take pleas in that case. And there'll be a time when if there's anything you want to add, it'll be important for me to hear from you. But it sounds like that'll be a little bit later this morning. So you're welcome to stay on the call. and at the appropriate time, I can hear from you, okay?
All right.
Thanks.
Thank you.
All right. Did the lawyers already, Ms. Clark, do you want to spend a little bit of time with Mr. Russell?
Yes, sir.
Great. Why don't you do that? And why don't we start with Mr. Montgomery's situation? Mr. Hood, good morning, sir.
Good morning, Judge. How are you, sir?
I'm well. I appreciate you dialing in on short notice. I just wanted to work through the motion for continuance that Mr. Hand had filed. I understand why he wants a continuance, but that doesn't necessarily mean you want one. And I wanted to let you know how I intended to address the state's concerns, and then I'll hear from you. It doesn't sound like it's directly on Mr. Hand that things as fundamental as a 911 call and a photo lineup, or at least the admonition, didn't land in his lap until just a few days ago. But more importantly, that is not Mr. Montgomery's problem. And so unless those things were exculpatory, my plan was to exclude them and have us move forward with Mr. Montgomery's trial if we reached it. I don't know if we will. There's a case ahead of it that seems like it is going to be a trial. But I wanted to get your perspective because it may well be that you want to see this evidence because it may shape your defense. It may be something you want to use. It may prompt more plea discussions. I have no idea, and you may not have much of an idea because you haven't seen it, but you also may have a real clear sense of this is bad news and is better for my client if it's not coming in. And then you may say, could we go first on Monday? So tell me your thoughts about it.
Your Honor, my inclination is we definitely would like to see the information and determine how it would impact our strategy going forward. Just to be quite candid, I believe this case should resolve short of trial. My client has not yet been so inclined. If Your Honor were inclined to grant the state's motion, I think that would impact resolution of the case. If Your Honor is not to grant that request, then we would be ready to move forward on Monday, and respectfully, we would ask that information be excluded. I'd like to see it before we can even make that determination, though, Judge.
So it has not yet been provided to you, or it's been provided, but you've been busy doing other things?
I have not seen it. So if it's been provided, I have not had an opportunity to review it.
Okay. Mr. Hand, what is you may not have it yet. You may have learned that it exists. What agency are you having to work with on this one?
Judge, this is Atlanta PD. I just want to make sure. I'm flipping through multiple different agencies. Let me just confirm, but I do believe this one is APD and not Hateville, Judge. 1 second. But he is correct that I have not provided it yet, Judge.
Okay.
Because I don't.
And have you not provided it because you don't have it yet?
I don't have it yet, Judge.
How did you learn that these things existed?
They are a part of the actual case. They're in the police report. They're all throughout other references by the detective. They just weren't a part of that, what I would consider voluminous discovery that was sent over in two waves, once in April, another recently in, I believe, just before November, Judge.
Okay. So Mr. Hood, you understand, it sounds like, but I just want to confirm it, that if I grant the continuance and this additional information is not favorable to Mr. Montgomery, that's going to end up being his problem and not anyone else's, because then you will have had enough time to review it, process it, and figure out if there's a defense against it. It may be neutral, it may be exculpatory, as I said, which is why you, I think, wisely are saying, I'd like to see the stuff. But it also could be inculpatory and further complicate things for Mr. Montgomery. But as long as you get that, and I know you do, but I need to hear you say that, then my inclination would be to continue the trial because it would be problematic, as in we need to try it again. If you got that information after trial and I had excluded it, and so Mr. Hand said, I'm just not going to fast forward it to you. And then it was exculpatory because it really ought to have been disclosed by law enforcement to Mr. Hand and then Mr. Hand to you long ago.
That's correct, Your Honor. We understand. We understand how that may impact us depending on what that evidence shows, Judge. But we really like to see it and review it, so we can inform this as to how to proceed.
Okay, Mr. Hand, what's your best guess as to an ETA?
Judge, I should have it next week.
Okay.
I've spoken to the detective. He has that. He said he's sending it to me. I just haven't received it.
And the detective is from what agency?
APD.
APD. Okay. Does APD usually have I don't know how you'd get your hands on 911. Does that typically, when that detective says, here's the case file, he or she has already retrieved the 911, or is that a separate process for your investigator?
Judge, that does normally come from APD when we turn over the detective file.
And it sounds like you got a bunch of stuff, but in it was not these things.
Yes, Judge.
Okay.
That's exactly it.
And is it Mr. Montgomery's case where at some point, if it goes to trial, we'll need an interpreter because an alleged victim or a witness needs interpretive assistance?
Yes, Judge.
Okay.
There are 4 victims and all 4 of them, well, my apologies. 2 of them speak English. The other 2, which are the parents of the 2, do not.
Okay, but that won't be trial length interpretation. It would be only if those witnesses are testifying, then we need an interpreter. We don't need to line up a team of interpreters to sit with someone for the whole trial.
Right, Judge.
Okay, that's much easier to manage. Okay, then Mr. Hood, what we'll do is keep this one on warm standby. So it'll probably pop up on the next trial calendar early next year. And if not the next one, because Ms. Nelson's already glued that one together, the one right after it, that'll give you more than enough time to review what Mr. Hand gets his hands on when things are finally produced to him. And then I'm hearing you that it may still have a non-trial resolution, but until it does, we need to keep it moving forward. Anything else, Mr. Hood, on behalf of your client?
No, Your Honor.
Anything else, Mr. Hand, on behalf of the state?
No, Judge.
All right, I'll enter an order granting the continuance, and in that order, I will indicate that the continuance was not opposed by the defense. Is that a fair statement?
That's correct, Your Honor.
Okay, all right. Mr. Hood, thank you for joining us on short notice. We'll be in touch soon.
Thank you, Judge. Have a good day and a good weekend.
You too. Bye-bye.
Thank you, Mr. Hood.
Thank you, Mr. Hand.
All right. Ms. Wood, do you have the people you need for Mr. Sexton's case yet? Some more people walked in. I just wasn't sure if it was the right group.
I do not see them,
They're
Judge.
from Mr. Sharp's.
Okay.
It's okay if we need to move forward.
Well, why don't we talk about Mr. Christopher's situation, and then we will need to move forward because I'll be out of other material. Mr. Christopher, why don't you come sit with Ms. Wood, please? And Ms. Rivers, we're going to want to take this down if you are available now.
Good morning. Yes, I am.
Great. Good morning. Thank you.
How are you?
What was the ankle monitor issue with Mr. Montgomery?
It wasn't county paid, Judge.
It is now?
It is now.
Okay, great. All right. Just get to your case. This is position 4 on our trial calendar. We've got Mr. Christopher here. It's a hit and run case. And Ms. Wood filed a motion, I think it was yesterday, it was very recently, seeking to enforce what she characterizes as a deal. And in her motion, Ms. Wood articulates the following timeline. About a month ago, Mr. Hand or his predecessor, but an assistant district attorney extended an offer that, it would have been Mr. Hand, that Mr. Christopher rejected in court when we called this calendar on November 8th. No, thank you. Whatever his words were, I don't accept it. So Mr. Christopher's case, which is one of the older ones on the trial calendar, was put on our short list, and it is set to go. In fact, it will be first out if the two defendants back in lockup enter pleas, and I've been told they are. Mr. Christopher is next, and we would try it starting on Monday. However, according to Ms. Wood, yesterday, Mr. Hand contacted Ms. Wood, Mr. Hand, the prosecutor, contacted Ms. Wood, defense counsel, to offer something new that apparently was more palatable to Mr. Christopher. Mr. Christopher and Ms. Wood met yesterday around 10:30, and Mr. Christopher said, "I'll take it." Then it sounds like Ms. Wood let Mr. Hand know that the offer had been accepted, and there were certain terms that were put in an email confirming what the deal was and that that's how things were moving forward. Then a little less than an hour later, Mr. Hand called Ms. Wood to say, it's not happening. I, Mr. Hand, have spoken with Ms. Newborn, Newborn, and the case is not working out. It's going to be a trial. Assuming those are the facts, it sounds like there is an enforceable deal, and pursuant to Sims, SYMS versus State, which I reviewed last night and which Ms. Wood cited, 331 Georgia Appeals 225, it is an enforceable arrangement. But that's an assumption, and I want to give both sides a chance to make the record they want to make, to help me understand, was there offer and acceptance in its basic contract rules here, and if there was detrimental reliance in the acceptance, then we need to move forward with the proposed deal. So, Ms. Wood, is there anything you want to add? I was parroting from your motion, and I may have missed something, overstated or understated something. But is there anything else you want to share to frame the issue? And then I'm anxious to hear from Mr. Hand.
Judge, very briefly, I just want to add on the record, we do see it as a valid contract. We relied on it after we accepted. I moved on to work on my other cases that are on the trial calendar. The state clearly continued to work on this case because the contact was made with Kayla Newborn after the fact that I accepted. My biggest beef with this is it affects the integrity of this justice system as a whole. Sims, the case that I did cite, says the integrity of the office of the district attorney demands that promises made by the district attorney are binding to the extent that they are valid and enforceable. It's my position this is a valid contract, and we just ask that you enforce the deal, Judge.
Okay. Mr. Hand, tell me your view on this and where these facts miss the mark, because if the facts are as they stand, you may be in a pickle because you've got someone who's frustrated with this possible outcome. But if you committed to a certain disposition and that was accepted, that may be how things need to move forward.
Agreed. Judge, may I approach the main podium?
Wherever you'd like to be, as long as Ms. Rivers can hear you.
Yes, Judge. Judge, I'd first like to say that there are two charges in this case, Judge. One of them is hit and run resulting in serious injury or death. The second one is a misdemeanor false report of a crime. I won't go too deep into the facts, but essentially there was a hit and run that occurred. The victim in this case, Mr. Matthew Duffy, was found on the side of a road, injured severely. He called 911 after regaining conscience after being hit by a vehicle, and police rushed there. Police found on the scene only parts of a car. They did not find a driver, a vehicle, or anyone that they could place at the scene other than the victim. The victim was hit such that he didn't see the car or the person who actually hit him with the vehicle.
Mr. Duffy was a pedestrian. He was on a scooter. He was on a bike.
Mr. Duffy was walking home from work early that morning, somewhere between 2 and 4 a.m. When he was hit, but he called police about 4:17 a.m.
Okay.
Judge, that occurred December 12th, 2020. A day and probably a half later on December 13th, at about 9:00 p.m., 2020, this is a Sunday, the defendant called the police and made a report that his car had been injured. He stated that that morning he dropped off his car in an empty lot. He was picked up by Kayla Newborn, who I had a conversation with that kind of spun this motion into action. And Ms. Newborn picked him up. He was with her all day. He came back at 9 p.m. when she dropped him off, saw damage to his car, didn't know what happened, called police, stated that it must have been sideswiped there in the parking deck. Roswell police responded, same police department that responded to Mr. Duffy the day before. And they analyzed the vehicle, noticed that there were no debris or anything around the car. But what they did notice is that the make and model were similar to a mirror that was recovered from the hit and run scene the day before. Also at the scene in the parking lot where Mr. Christopher called the police was Ms. Kayla Newborn. She corroborated his statement. She said that she did indeed drop him off around 10 a.m. that morning, came back with him at 9 p.m. and that's when they noticed the damage the first time. Judge, we made contact with Ms. Newborn at least twice since that incident. We spoke to her. She has not been inconsistent in her statement. She, may have said a few times, I don't remember, but she has been consistent with that statement. And I contacted her early as a few weeks ago. I apologize for not having that date and time. Just looking at that evidence, the state realized, made an offer to Mr. Christopher, including a plea to both counts.
This was the November 8th offer?
Yes, Judge.
Okay.
It was rejected, as you know. And part of that rejection was there being a statement that there was no evidence placing Mr. Christopher at the actual hit and run. After talking to another individual who's in the lot, Judge, we concluded that there was certainly enough evidence for the false report of a crime, but not enough for the hit and run. The sole basis of us making the revised offer, which I made to Ms. Wood yesterday, was because there was no evidence on the hit and run.
And the revised offer was a plea to just count 2 to the misdemeanor.
Yes, Judge. So thus the state's plea offer reflect the evidence that we had and that would be shown at trial. Judge, so I reached out yesterday morning, made the revised offer. Defense counsel conveyed an acceptance at 10:59 a.m. via email. The specifics of that acceptance was confirmed, Judge, by myself at 11:05 a.m.
So you're not disputing, hey, we had a deal. You're about to tell me how things changed, as in, it sounds like Ms. Newborn changed her story and said, I've been covering for Mr. Christopher all along.
Absolutely, Judge.
Okay.
At 11:27 a.m., Kayla Newborn gave me a telephone call. I picked up. She stated that she had been receiving text messages from the defendant the day before, expressing his displeasure that she was on the witness list testifying against him. She also noted that her address was on that witness list And so she was afraid that he knew where she lived, where her parents lived, her brother, and she was afraid. So she changed the story, Judge. She said, I know exactly what happened. I want to tell you what happened. She disclosed to me that she was present during the hit and run incident on December 12th, that the defendant was present. The defendant was driving at the time.
So she was a passenger in the car when it happened.
She was a passenger in the car. She explained it was about between 3 and 6 a.m. in the morning. She was with him. She'd gone through a breakup and was just hanging out with him. Judge, what was important about that is she explained how he circled back after the hit, looking for his mirror. And at some point just began randomly yelling to her to get in the car and sped off. She didn't understand why. She didn't know if he saw anything, whatever. It was weird to her. Then he wouldn't let her leave. He told her she had to go to a hotel. She disclosed all of this information, but the most important part is that she stated that night when when Mr. Christopher called the police, he told her, this is what you're going to say. You're going to tell them that you dropped me off at 10, we were gone all day, and then and then you dropped me back off at 9 p.m., and that's when we noticed the damage. She divulged to me that her testimony had been influenced not only 2 years ago, but as recent as 2 days ago by her feeling, she felt threatened. I can't say threats were actually made, but by her receiving text messages. The whole point of that is to say, Judge, is that the plea offer that was made was based on information that was known. Specifically, it was based on information that had been influenced by the defendant. And so it's the state's position that if the defendant can influence witnesses' testimony, conceal evidence in order to get a plea offer that he believes to be better for himself, that is essentially rewarding what we would call, what's even a felony, right? Influencing witnesses. And so it's the state's position that one, the court is not, while contract law is a framework, Judge, for understanding a plea agreement, whether it's enforceable or not, this court is not bound to enforce that plea agreement. Gramiak v. Beasley, Judge, I will cite 304 GA 512 says that in Georgia, a trial court is not bound by a plea agreement between the defendant and the state and has the discretion to refuse to accept a negotiated guilty plea. More specifically, Judge, I would refer Your Honor to a case that's Clark v. State, that is Georgia 360 Georgia App 11. I'll provide a copy. May I approach, Judge?
Sure.
Thank you.
Judge, this case, the state would posit, stands for, it's the court's responsibility to govern the administration of justice and to protect the community, particularly vulnerable populations. Thus, a trial court is not required to enforce a plea agreement where the prosecutor obtains newly discovered information of the defendant influencing witness testimony, such that the trial court determines that the plea agreement would fail to adequately protect the community, in particular, such witnesses. Judge, this case involves very similarly a defendant that was headed to trial. The basis of it was a physical altercation between himself and the 78-year-old mother of his. Throughout the process, the state made different plea offers at a hearing occurring just a few days before trial, similar to today's matter. The defense counsel initially announced that the defendant wished to proceed to trial, but during a recess of that same hearing, the defendant changed his mind. He accepted the plea offer that was one of the plea offers given by the state judge. And during that same recess, the prosecutor learned of recorded calls that the defendant made to his daughters during jail, causing the prosecutor to decide to withdraw the plea. Those calls were made to specifically influence those witnesses' testimonies about the instance where he was allegedly physically harming his 78-year-old mother. It also included letters that were sent to her asking her to not testify. When the hearing resumed from that recess, Judge, the state stated that Mr. Clark wanted to accept the plea. They were aware that he accepted it, but they could not proceed. I will tell you that case does differ because defense counsel did not object to the withdrawal. However,
On the motion for new trial, the appellate counsel said it was error for the judge to allow the withdrawal to occur, and maybe ineffective on defense counsel for not having pushed to enforce it. But the Court of Appeals said that it was okay for the trial judge to exercise that discretion to refuse to enforce what may have been a negotiated plea agreement, in particular because of the recently discovered evidence.
Exactly, Judge. And so specifically about that case, the reason the court was permitted to is because the newly discovered information was not accounted for in the plea offer. And the court decided that the new plea offer, taking into account the newly discovered jail calls, would more adequately protect the public. And so it is the state's position that the new information about Mr. Christopher influencing testimony of Ms. Newborn, simply permitting him to plead to the agreement that was negotiated, no processing the first count, which is hit and run. Although now that we have evidence placing him directly at the hit and run, and simply receiving a probated 12-month sentence, which would have been the offer, does not adequately protect not only Ms. Newborn, who came to my office shaking and crying. And, if Your Honor would like to hear from our detective, who was also present during that instance, I'll be able to get Detective Peroni here as well. But
in what instance? Meaning yesterday when Ms. Newborn was saying, let me tell you the full story. It wasn't just you and your investigator, but Roswell PD was plugged into that conversation.
No, Judge. What I meant to say is my investigator Peronis is the investigator for our office.
DA's investigator.
DA's investigator, Judge.
It doesn't make him less of, or she less of an investigator. I'm just trying to understand, is it your office's investigator or was Roswell in the mix?
Ours, Judge.
Okay.
And not only did she make the statement, she came into our office to make a written statement, which I've turned over as well to Ms. Wood.
Is Ms. Newborn in a safe place, or how are you working through the recent developments, given that she expressed concern about her address being out there?
Well, Judge, I did make contact with the defense and notified them that the defendant was contacting her in a way that we felt was influencing her testimony as well. I'm not sure what action they've taken from there, but I've also notified the investigators. I'm not certain, Judge, what the investigators are doing in order to adequately protect Ms. Newborn.
Okay.
What we are requesting is, not enforcing this agreement, this plea agreement, Judge, would allow the state to proceed on the trial of the hit and run, which we now have direct evidence showing that Mr. Christopher was there. And, instead of him being probated and being able to walk out of this courtroom free to, if possible, further harass or contact Ms. Newborn, show up at her place of residence, her brother's place of residence, who also stays at that same residence with her, then he would be forced to go to trial on hit and run. And if convicted, Judge, would serve a sentence that the court determines. The state's position is that that would be an outcome that would be taking into consideration the protection of the community based on facts that were directly influenced or disclosed, or concealed by the defendant. The state would also state that the Sims case, which was cited by Ms. Wood, is a completely distinguishable case. There's no intervening newly discovered facts or information. There's no.
I don't know that it's distinguishable so much as it sets forth a principle that can apply. You're saying it doesn't apply in this situation, but basically, and I'm gonna hear from Ms. Wood in just a minute, you're arguing, without using the contract phrase, fraud in the inducement. You were led to believe that there was no information that you could get your hands on that would connect beyond, hey, this mirror kind of matches kind of thing, that would connect Mr. Christopher with the hit and run of Mr. Duffy.
Yes.
And you were led to believe that in part by Ms. Newborn saying, here's the alibi. But that fraudulent statement was induced by, you think the evidence would show, Mr. Christopher. He convinced you to enter into this contract by duping you. And those kinds of contracts are unwound all the time if one party of the contract says, well, I only did it because, and that because ends up being something that is demonstrably untrue at the hands of the other party to the contract. I'm not putting any of this on Ms. Wood. She's relaying what she knows from her client, but that's your argument. And so really what Sim says is it's okay to use contract principles in enforcing a plea deal. A foundational contract principle is there's really not a deal if one side was tricked or defrauded or duped into agreeing to the contract.
Yes.
That's the scenario that you have painted here.
Yes, Judge.
Okay.
If I may be allowed to end on one point.
Sure.
I agree with that. Judge, there's also one thing cited by the defense in their motion, which is that there's a policy reason for enforcing the agreement, which is the great ends of justice. And, the state would just state its positions that it's not just to permit a defendant to benefit from what we see as purposefully concealing information and preventing the discovery of truthful evidence of its guilt by directly silencing a victim and also a witness in this case, Judge. Were this court to enforce the plea agreement based on the absence of evidence, placing the defendant at the scene where the lack of evidence is the fault of the defendant for concealing it, the state would its position would be that it would be a reward for such behavior and not going to the great ends of justice as well. So that would be the state's position. Judge.
Got it. All right. Thank you. So, Ms. Wood, it's always good to hear both sides of a debate. Tell me your thoughts about what you've heard, and in particular, whether you've had a chance to speak with Ms. Newborn, and you may have tried, and she may have said, I don't want to talk to you. I understand this is all fast developing. And as you mentioned, you moved on to other cases after you thought you had sorted this one out.
Judge, I do believe less is more, but there's a couple of things I would like to get on the record for this. This case, the incident date is alleged to have been December 12th, 2020. We're almost to the 2-year mark for that. The original witness list had no information for Kayla Newborn. However, my investigator has been working diligently to reach out to her and get a statement prior to any of this happening, because as I mentioned in my motion, this case has been dragging along for quite some time, and we were having issues even getting an offer in the first place. She has not elected to speak with our office, and that's okay. I do want to point out, the state told the court that they had spoken to her prior to this being conveyed. And then all of a sudden she changed her story later in the day yesterday. Well, that's a state problem. That's not a defense problem. That's a witness credibility issue. As this honorable court has said, a deal's a deal. The offer was made over the telephone. We talked about it in my office yesterday. I sent an email accepting the offer. He responded back with the terms of the agreement. We spoke with your litigation manager. We had it down for 9 a.m. today for a plea. That's why he's here today, to take a misdemeanor plea. If the court is concerned about him talking to Ms. Newborn or talking to anyone that he shouldn't be talking to in this case, we are fine with a stay away, no contact order. We ask that you enforce the deal, Judge.
Okay. Mr. Hand, what do you have that I could see that documents some of what Ms. Newborn was sharing, specifically texts or communications from Mr. Christopher of late? As you said, one of the things that she shared with you is I'm hearing from Mr. Christopher about why am I even on a witness list?
Yes, Judge. He sent her text messages that I can show for the court. Those have been turned over to Ms. Wood as well, Judge.
Okay, I'd like to see those. And I also want to be clear, there was no prohibition that I'm aware of Mr. Christopher communicating with Ms. Newborn. So the fact that they were communicating isn't something that troubles me. It would be, of course, the substance of that communication, because it is influencing witnesses to tell someone to say something that's not truthful in a court hearing. So what I'd like to do is put this one on pause and take a look at those things you described, whether it's something you can email me or they're on your screen or whatnot. And we'll work through that. And in the meantime, why don't we see if we can take any of these pleas? So Mr. Christopher, I'm gonna ask you to stay here, but go back to the gallery. Thank you. And are we ready with Mr. Russell?
Family is outside.
Okay.
I'm emailing those to you now, Judge.
Thank you.
Thank you.
I'll just.
What are we hearing from Mr. Sharp, Mr. Abate? Do you know, is that coming together?
I believe so.
Okay. We could do that one if he's ready. I don't know if Mr. Sharp is ready, but I don't think he's outside. Is he outside too? Oh, okay. Whoever can come in first, let's do that one. Okay. I know, Ms. Hudson, you'd like to move along. So if we can do Mr. Russell first, that's great. But I just need a lawyer in here because we're going to run out of time.
I provided the information that Ms. Nelson would need from me as far as the days,
Okay.
because I have to be with Judge Carmichael at 10 o'clock.
Okay.
So I'm probably gonna head out.
Have to scoot anyway. Well, thank you for being here.
Yes, sir.
Ms. Wood?
Judge, Mr. Sexton's family is here. If it's okay, I just want to step out in the hallway and I'll be back in.
Sure.
Thank you.
Not sure which one we're going to do first. Hopefully Russell. Mr. Abate, does it matter the order in which we do it? Is that going to influence things or you're neutral?
It doesn't matter to me since I made my offer 6 months ago, so.
They should be separate. Don't have them plead at the same time.
They could plea at the same time. The officer, just a little bit different. Mr. McKinnon is 25 years to serve. Mr. Russell is 25 years to serve 20 with a balance of 5 years on probation.
Okay. I'll ask Ms. Clark. Hey, Ms. Clark, I was just asking Mr. Abate, do you want the pleas to be separate or can we have both defendants out here and we do them at the same time?
No, we can do it separate. I mean,
My preference would be do them together because it's the same general factual basis and obviously the same questions, but I never impose that on defendants. If the state sometimes says, nah, it's not smart to have them out here at the same time. Mr. Abate said he's neutral, same, do them together or separately. Do you have a preference?
It might be sort of emotional for them to be together. Maybe we should do them separate.
Okay, let's bring Mr. Russell out, please.
Thank you, Judge.
You're welcome. You tell me, Ms. Clark, do you want to have Mr. Russell up at the podium with you, or do you two want to be, you can be seated because we can see and hear you just fine.
Yeah, we could be seated.
Okay, yep, so in the middle seat, please.
Thank you. Your Honor, in this courtroom, do you sign the indictment for?
We're going to do that electronically,
Okay, thank you.
but I need a prosecutor.
Your Honor, may I ask a question?
Yes, sir.
In preparation of the next case, are there plea forms?
There are, you're talking about for Mr. McKinnon?
Yes.
There are, if you have the time to fill that out, that's great, given the significance of the plea. We've been doing less paperwork for burglary or something, but for something like this, it'd be great. There should be a form there. That's okay.
No, I don't see a plea.
Okay, then we will just make a good written record through our court reporter.
Awesome.
All right? All right. Mr. Abate, are you ready?
Your court reporter's name is?
Ms. Rivers.
Ms. Rivers.
I'm gonna make sure she's ready in just a second. The little guy or gal's gonna need to be outside, only because Ms. Rivers is gonna need to be able to hear what's going on. Which case are you here for, ma'am? Is that Mr. McKinnon? Oh, okay, when he is in here, we'll try to figure out a way to have that person in here too. Okay? All right, Ms. Rivers, are you ready?
Yes, Judge, I'm ready.
All right, this is a plea in case 22 SC 181907. It is State versus Russell. Mr. Russell is in here with his lawyer, Ms. Clark. Mr. Russell, are you ready to move forward this morning?
Yes, sir.
Okay, when you are answering questions, and most of them will come from the prosecutor over there, I need you to make sure that you speak as loudly as you can into that microphone so that the court reporter can hear you. If at any point you cannot hear what's going on or you don't understand what folks are talking about, will you let Ms. Clark or me know?
Yes, sir.
Great, and that was a great answer. Thank you. Mr. Abate is about to put you under oath. Once you're under oath, it's important you answer his questions truthfully and completely. If you've got any questions of your own, as I mentioned, you need to make sure you bring them up with Ms. Clark or with me. Mr. Abate, when you're ready.
Mr. Russell, please raise your right hand. Best to your ability. Do you solemnly swear and affirm that the testimony that you're about to give in the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
You can put your hand down. Could you please state your true, correct, and legal name for the record?
Patron Russell.
And Mr. Russell, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take on a regular or daily basis that you have not taken today that would affect your ability to understand why you're here today?
No, sir.
Mr. Russell, how old are you and how far have you gone in school?
17, 9th grade.
And are you able to read, write, and understand the English language?
Yes.
And do you understand that you're charged with the following offenses? Count 1, murder; count 2, felony murder; count 3, aggravated assault; and count 4, possession of a firearm in the commission of a felony.
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And have you had enough time, or do you need any additional time to speak with your attorney, Ms. Clark, about the rights that she explained to you that you were waiving?
No, sir.
And are you satisfied with the services she's provided?
Yes.
And Ms. Clark, do you waive formal reading of the indictment?
Yes, we have reviewed it.
And Ms. Clark, have you advised your client of the minimum and maximum sentence for each charge that he is pleading guilty to? And have you explained to him that count one murder will be reduced to voluntary manslaughter OCGA 16-5-2, that count two upon his plea of guilty would vacate by operation of law, that count three aggravated assault would merge with count one, and then the sentence for count five is 5 years to run consecutive, but can be suspended, probated, or served in prison.
Yes.
And Mr. Russell, do you understand that this is a negotiated plea of guilty, which means the state and your counsel will make a recommended sentence to the court, but the court does not have to accept the recommendation, and the court can sentence you to the maximum on each charge and run those sentences consecutively, which means one after another.
Yes, sir.
You're gonna have to speak up a little bit.
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else, sir?
What?
So, do you understand that? Sure. Do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anyone else?
You're a US citizen? You're born here, right?
Mm-hmm.
Right. So it doesn't affect you. So just say yes, sir.
Yes, sir.
Okay. And do you understand, Mr. Russell, that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you were unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. Mr. Russell, do you understand that you're waiving or giving up all of these rights by pleading guilty here today?
Yes, sir.
And Mr. Russell, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No one forced you or promised you anything to enter a guilty plea. You say, do you understand? No.
I promise to get a Lord parole.
No.
So, Mr. Russell, you,
Parole if
the-
you behave.
Yeah.
the promises that may have been made in terms of what the state's going to recommend, those are okay promises. And as long as those are the promises you're thinking about, I don't have an issue with that. But if someone promised you, hey, I'm going to take care of your family, just take this plea and make life easier for Mr. McKinnon or something like that, I'd need to know about those. But it doesn't sound, I see you shaking your head. The only promises you've heard, maybe Ms. Clark has told you, here's what I've negotiated on your behalf. Here's what the state's going to recommend. Those kinds of promises. Is that what you're thinking of?
Yes.
Any other promises?
Oh.
Okay.
He was questioning about parole, and I told him it was a parolable sentence, and it all depends on his behavior in the facility, how soon he would be paroled.
Exactly.
Okay, so I'll ask the question again. Is it your decision to waive, or has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today, sir?
No.
Okay, and is it your decision to waive these rights and enter a guilty plea here because you're in fact guilty, sir?
Yes, sir.
Okay, and how do you plea to the charges in indictment number 22 SC? Where did I put that? Judge, do you have the indictment?
I do. It's 22 SC 181907.
22 SC 181907, count one, which is murder being reduced to voluntary manslaughter under OCGA 16-5-2. How do you plead to count one?
Guilty.
I couldn't hear you. What'd he say?
Guilty.
Okay, and how do you plead to count 2, which is felony murder, that will vacate by operation of law?
Do you want him to plead to it?
Yes, it will vacate by operation of law upon his plea.
It will be vacated by operational law. It doesn't affect your plea.
Guilty.
And how do you plead to count 3, aggravated assault, which will merge with count 1?
Guilty.
And how do you plead to the last count, count 4, possession of a firearm and the commission of a felony?
Guilty.
And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, Mr. Russell?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
And do you understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea?
What do you mean?
You have 4 years from today's date to challenge a guilty plea, saying that it was not freely and voluntarily given.
All right.
You have that much time. You could ask the question again?
Sure. After speaking with your attorney again, Mr. Russell, do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging this guilty plea?
Yes, sir.
Okay. Your Honor, had this case proceeded to trial, the state would have been able to prove beyond a reasonable doubt that on August 30th of 2021, at approximately 6:44 p.m. At the L&L grocery store, which is located at 617 Joseph E. Boone Boulevard here in Atlanta, Georgia. The defendant, Latron Russell, was hanging out with his co-defendant, Mr. David McKinnon, as well as another individual whose nickname is Cash, which is Kash. Later was identified as Dwantavius Aldridge. All of the interactions between Mr. Kinnon and Mr. Russell and Mr. Aldridge are captured on VIC video surveillance, which the city of Atlanta has several cameras all throughout the greater Atlanta area. At moments after the defendants arrive and are hanging out in front of the grocery store, the victim in this case, Mr. Marquise, Markeece Jenkins, also arrives at the grocery store. He can be seen on the video surveillance walking up from Joseph E. Boone and going straight into the store. He is in the store for about 3 or 4 minutes. While he is in the store, you can see the defendants, Latron Russell and David McKinnon, go to the side of the grocery store, which is where Joseph E. Boone and Vine Street kind of meet right there at the corner in front of the park. At that time, it can be captured on video surveillance. Mr. Cash or Mr. Aldridge passing a gun to David McKinnon, which you can see David McKinnon then put in his waistband, and they continue conversing on the side of the building until they move back to the front of the grocery store and hang out in front of the bench where they had previously been conversing. Moments after the transfer of the gun to Mr. McKinnon occurs, the victim comes out of the grocery store. He's got a bag of chips and looks to be a yellow pineapple drink or something like that, that he eats his chips and hangs out also in front of the store, kind of conversing with Mr. Aldridge in the wheelchair, as well as Mr. McKinnon and Mr. Russell. As they are conversing, you can see that Mr. Russell is sitting back on the bench, which is in front of the convenience store, and Mr. McKinnon is standing a few feet away, resting his back against a pole. And the video would show that as Mr. Jenkins is continuing to converse with all three of the people mentioned, Mr. Russell, Mr. McKinnon, and Mr. Aldridge. Mr. Russell immediately jumps up from the bench and attempts to take by force the book bag of Mr. Marquise Jenkins. You can see there's a struggle. that moves from the sidewalk into the street. As the struggle immediately occurs, you see Mr. McKinnon come off of the pole, immediately pull the firearm from his waistband and closely move with the struggle in which Mr. Russell is trying to steal what the state would say is the bag of Mr. Jenkins. The video then stops kind of there because it doesn't extend I guess the lens. They go off screen, for lack of better words. At that point, witnesses would say they hear several shots. In fact, there is 2 Zone 1 police officers, Officer Coleman and Officer Ross, who are at 581 Joseph E. Boone at the IPBO building. They immediately hear the gunshots and immediately take off from their vehicle and run down the street. They miss seeing the defendants by less than 10 seconds. They immediately come up on Mr. Jenkins, who has been shot 4 times in the leg. One of the shots entered his thigh, went up and severed his femoral artery and remained in his vertebrae of his back. So ambulance and medical personnel arrive immediately and they attempt to provide life-saving measures on the way to Grady. But unfortunately, Mr. Jenkins, was killed and he succumbed to his injuries. At that point, there was an investigation done by Detective David Jenkins, not related to Mr. Marquise Jenkins. And from that point, he is able to get the video surveillance, not only from the Vic camera, but also from inside the L&L grocery store, which he is able to do a bolo for both defendants. And there's Crime Stopper tips, as well as an officer, Officer Tyler Davis, who had arrested Mr. Russell 5 days before the incident occurred. And so he was able to identify Mr. Russell along with his mother. After speaking, after getting the video, the detective went to Mr. Russell's mother, Miss Krishandra Brooks, showed her the video. She identified her son in the video, that she recognized him. And as it pertains to Mr. McKinnon, he was also identified by, when they put it out in the news, he worked at the Kroger Distribution Center, and several members of his employment identified that as the person they knew to be David McKinnon. Upon that, Your Honor, arrest warrants were taken out for both Mr. Russell and Mr. McKinnon. Mr. Russell was arrested on January 12th of 2022 here in Zone 1, so not far from the courthouse at 641 Jones Street. The circumstances of his arrest were that he was in Midtown around between 7 and 8 o'clock p.m. He was at the Vortex restaurant right there on Peachtree Street in Midtown. An Uber driver had left his car running in order to get the food that he was picking up. Within the less than 30 seconds that his car was unattended, the defendant jumped into the driver's seat and stole the vehicle. He then left the area of the Vortex. I guess, unfortunately for him, the victim had a tablet inside of that vehicle, was able to track his every move, and the helicopter Phoenix that APD has was able to track the vehicle by using the tablet and locate it. It's all caught on video. The defendant attempts to, I guess, hide the vehicle and escape. When he realizes that the police are hot on his trail, for lack of better words, he decides to abandon the vehicle. He can be seen from the camera jumping out of the driver's seat. He is the only occupant of the car, jumping over the vehicle, jumping over fences and walls, and then attempting to hide in a dumpster. He is eventually located by members of Zone 1 Atlanta Police Department and arrested at that time. And he's remained in the custody of either RYDC or the Fulton County Sheriff's Department since his arrest on January 12th, 2022. He does, because of his age, I believe he's 17 today. He was arrested when he was 16. He has no felony criminal history. He does have some juvenile history, nothing major other than things that we've discussed, entering autos and things of that nature. He was reported as a runaway at one point as well. So the offer that the state has extended to defense counsel is 20 years to serve on count 1 to the reduced count of voluntary manslaughter. Count 2 would vacate by operation of law. Count 3 would merge into to count 1, and then the last count 5, possession of a firearm during the commission of a felony, would be 5 years consecutive but probated for a global sentence of 25 years to serve 20 with a balance of 5 years on probation. Nothing further from the state.
All right. Question. We know where Mr. McKinnon is. He'll be coming out soon. Cash. What happened with Cash? Just not someone the state elected to charge?
So that is, so Miss Detective Jenkins on several occasions attempted to locate Cash. He was unable to. I have once I received the case, so Cash was obviously not indicted. I have attempted to make contact with Cash and have been successful over the telephone. What I learned through my investigators' search for Cash is that he is a blood relative to Mr. McKinnon. And through speaking with Mr. McKinnon's, or through speaking with Mr. Aldridge's mother, who was Mr. McKinnon's aunt, it's been made clear that Cash is not going to cooperate. Cash is not coming in, and Cash has turned his phone off. So we've been unable to get in contact with him. He currently has now a warrant for probation outstanding, and Fugitive is looking for him actively. I've been monitoring the jail calls for Mr. McKinnon and Mr. Russell pretty closely for the last couple of weeks. There is a phone call from November 8th in which Mr. McKinnon is speaking to his mother. And at that time, his mother is with Mr. Aldridge's mom, and they're on the phone basically saying that, don't worry, Cash isn't coming. So he's actively hiding, and it is my intent to charge him with at least possession of a firearm by a convicted felon after this plea is completed.
Okay, thank you.
And Mr. Jenkins' grandmother, who raised him from a very young age, Miss Sandra Jenkins, is on the call. When Your Honor deems appropriate, she'd like to make a victim impact statement.
Sure. In just a moment, we'll do that. Ms. Jackson, good morning. It sounds like there won't be anything in the research you can do on Mr. Russell. Is that a fair statement?
That's correct, Your Honor. No juvenile.
Okay, thank you. Ms. Jenkins, we've spoken before, not just today, but on other dates. Is there anything more you want to share about your loss, your family's loss? You're on mute right now.
Can you hear me now?
Now I can hear you. And Ms.
Okay.
Jenkins, let me share this. We're going to be taking Mr. McKinnon's plea in just a moment, and it may be that you want to save your thoughts until we take Mr. McKinnon's plea. It sounds like from the evidence, he's the one who shot and killed your grandson, as opposed to Mr. Russell, who clearly had a role in it, but wasn't the man with the gun. I'm happy to hear from you twice. I don't want to make you have to share your thoughts and process this more than once. And so if you'd prefer to wait until we take Mr. McKinnon's plea, that's all right with me.
I understand. Thank you.
Okay, so I'll get back to you once we do Mr. McKinnon, all right?
Thank you.
Thank you.
And Judge, before we move on to Ms. Clark, can I make one more statement for the record and for the court?
Sure.
I want to make it real clear for the record for the court that I believe that the defendant actually deserves a life sentence based on his actions that he did on August 30th of 2021 through the persistent contacts by his counsel and her diligent work. providing mitigating circumstances and things of that nature because of his age is the reason that the state has even entertained this resolution. I believe the resolution is appropriate, but I also believe that a life sentence is also appropriate. Through the autopsy and through the, I guess, medical intervention that they attempted to provide to Mr. Jenkins at Grady Hospital, they did locate a .45 caliber projectile that came out of his body, which would indicate that there were two people shooting, most likely, because the victim had a .40 caliber weapon, which cannot fire a .45 caliber projectile, and a 9mm cannot fire a .45 caliber projectile. Now, I will be candid with the court. You can't see a gun on Mr. Russell at all during that video, but there's only two people who attacked Mr. Jenkins, which would make very clear that circumstantially, the only people who could have shot Mr. Jenkins are both Mr. Russell and Mr. McKinnon. But because Ms. Clark has been persistent and contacted me frequently, we were able to finally come to a resolution, which I believe is fair. But I wanted to make that clear for the court that the only reason this is being considered by the state is because of the work Ms. Clark has done and provided to her client.
Okay, understood. And I heard nothing that suggested there were evidentiary weaknesses in the state's case or anything like that, but that you had concluded that this was a reasonable outcome. None of this brings Mr. Jenkins back, but it does avoid the need for a trial and people having to work through that. And it also delivers some certainty to everyone involved, where trials don't necessarily do that. All right, Ms. Clark, tell me what you'd like to share about Mr. Russell, please.
Your Honor, Mr. Russell was 16 years old at the time of this incident, and he and I and his mother, well, his mother has seen the video more than once because the detective brought it out to her house, and she did identify her son as the person struggling or fighting with the victim in this case. Your Honor, Mr. Russell has never been seen or known to have a firearm. And he indicates that this was a fight. He wasn't trying to take the victim's pouch, which contained drugs, a scale, and a large amount of cash, but he was trying to prevent him from pulling out a firearm, which according to the police, he had in his hand when they ran up to where he laid on the ground. They were able to take his firearm away and attempted to render aid to him. And my client, Mr. Russell, had run away. He did not instruct Mr. McKinnon to shoot the victim in this particular case. But Your Honor, as I indicated, he was 16 years old at the time. He does have the love and support of his family. His mother and his siblings are here in court. And we've gone over the plea agreement with both him and his mother. I have. And Mr. Russell understands that the reduction to voluntary manslaughter allows him to have parole. And that the situation, if he had gone to trial and failed, he would have a life sentence, which is a minimum of 30 years before you're even eligible for parole, but that they do not have to let you go at all if they choose not to. This way, Mr. Russell at least has an opportunity to get out and be paroled prior to the 20-year sentence. And he understands that it's on him and his behavior and how he does in the facility and whether he wishes to participate in any type of programs to better himself, whether the parole board would let him out early. And that's what his goal is. I've discussed the first offender with him and explained that both sides of it to him, and he doesn't wish to take advantage of the first offender treatment. We're asking, Your Honor, that you accept the negotiated plea at this time. and that Mr. Russell be allowed to show society that he should be paroled and back out in society again.
All right. Well, thank you, Ms. Clark, for that, as well as the steps you took to advocate on behalf of Mr. Russell. They were effective. Mr. Russell, is there anything you want to add? You don't have to say anything more, but you have a right to be heard if there is anything you want to share at this point.
I would like to apologize to the victim grandmother for everything, the loss of her grandson.
All right, thank you. Mr. Russell, I find there's a factual basis for your plea, that you were mixed up in this in some way, and it could well be that the jury concludes in the end that you had a gun and you fired the gun. That's not what I'm finding. I don't need to find that. I need to find that there's evidence that you were a party to what happened between Mr. Jenkins and you and Mr. McKinnon, and to the extent that Mr. Aldrich was involved, Mr. Aldrich. I also find that your plea is knowing and voluntary. Knowing means you've understood everything. Either you understood it the first time, or, as I saw you do several times, which was great, you asked Ms. Clark to explain it more, and she did, and then you indicated that you understood. Is there anything about what we've been discussing that right now you do not understand?
What time, when would I be eligible for parole?
So it's a good question. That's one that I don't think anyone here can answer. Let me tell you a couple things about time. You will get credit for all the time you've been in. So you've been in almost a year now, and that will be credited towards your 20. You are parole eligible because this is a plea to voluntary manslaughter. Pardons and paroles has a set of criteria they look at to include how serious the offense is. This is pretty serious. How serious your criminal history is. You don't have a criminal history, so that's good. How you're doing, and Ms. Clark said this several times, where you're being housed. If you're getting in trouble all the time, no one's going to be interested in parole. But if you have taken classes and you're a trustee and you get moved from higher security to lower security, then those are all the things that people look at to say, that's someone we need to have a conversation with about parole. But I can't give you a date. It's going to be March of 2029. It's actually not even my decision. I could put in the sentence, I think Mr. Russell is someone you should really think about for parole. I don't have that opinion, but it wouldn't matter because it's not the court that decides that. It's pardons and parole. And I'm sure Ms. Clark has told you about that. So I know you'd like to have a date certain. What I can tell you is you can make that date sooner by making smart decisions as you go forward. Do you have any other questions?
No, sir.
Okay. I also find that your plea is voluntary, and I will accept it. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that once you are on parole, because it's the same group that supervises you, parole and probation, so you're going to have 5 years probation. That's part of your sentence. But you're going to have a longer period when you're supervised if you're paroled. So while you are on parole or probation, if you have a small violation, you and parole or probation will work through that. But if it's something significant, you get arrested again, you have a gun, anything like that, that'll come back to a judge to work through. Mr. Russell, do you authorize my staff to electronically sign the indictment for you, indicating your guilty plea?
What do you mean?
So what we used to do is we would have your indictment, a piece of paper, and you'd sign it. Patron Russell, I plead guilty. You've already said it, but you also signed the indictment. And Ms. Clark would sign it, Mr. Abate would sign it. But we're doing that electronically now, so we don't have to move papers around. But I need each person to say, that's okay, you can sign it for me because we don't have a way for you to sign it on the screen. Is it okay if my staff signs the indictment for you?
Yes, sir.
Okay, Ms. Clark?
Yes, sir.
And Mr. Abate?
Yes, Your Honor.
All right, I'm going to follow the recommendation in this case, Mr. Russell. On count 1, which has been reduced to voluntary manslaughter, I'm sentencing you to 20 years to serve. Count 2 is vacated by operation of law. Count 3 merges into count 1. Count 4 has to be 5 years. It has to be consecutive, but I can probate it, and I will. So it's a total sentence of 25 years, the first 20 to serve, the last 5 on probation. You'll get credit for all the time you've been in. It sounds like your arrest date was January 12th of 2022, but that'll be in the system and you'll get credit for that. Mr. Russell, those are all very big numbers, especially for someone your age. They're big for someone my age, but those are big numbers, but they reflect the seriousness of what you got mixed up in. None of this brings Mr. Jenkins back. My hope is, I know it's Ms. Clark's hope, it's what she shared with me, is that from this, you'll take the opportunity to improve, take classes, do what you can while you are locked up so that when you get out, and you know you're going to get out, which is a different outcome than if you went to trial and were found guilty. You know you're going to get out, and that date will soon approach. You'll have a chance to make a different set of decisions and reconnect with family and hopefully move in a different direction. But that is something for you to work on. Mr. Abate, anything else in Mr. Russell's case?
No, Your Honor.
Ms. Clark?
Yes, Your Honor, regarding the credit for the time served, Ms. Singleton has left Ms. Nelson with the time from January 12th of 2022 till his birthday of May 15th of 2022 has to be on the sentence sheet in order for him to get the credit because he was at Metro at the time.
Got it.
And they do not certify like the jail does.
Okay, I'll make sure that's in there. And if there are any issues with that, I will gladly amend the sentence to correct it so it reflects all those months as well. Okay. All right. Thank you. Let's bring Mr. McKinnon out, please.
Thank you, Your Honor.
Yes, sir. You may. Like comprehension issues or resistance? Okay. Understood. We run into that. Mr. McKinnon, if you could come up to the podium, please, and stand by Mr. Sharp. I'm all right. I mean, it'll be easier to hear him if that's okay. If you're all right with that. Okay, good. Ms. Rivers, you ready?
Yes, I am.
Great. This is case 22 SC 181907. It's State versus David McKinnon. Good morning, Mr. McKinnon.
Good morning.
Mr. McKinnon is here in court with his lawyer, Mr. Sharp. We have Mr. Abate as the prosecutor. It's my understanding, Mr. McKinnon, that through the good work of your lawyer, you are prepared to enter a negotiated plea to a reduced charge, reduced from murder. Is that correct?
Yes, sir.
In just a moment, Mr. Abate is going to put you under oath. Once you're under oath, you're going to need to answer his questions and mine truthfully and completely. Will you do that?
Yes, sir.
It's also important that if at any point you have questions of your own, you don't understand what someone said, or you can't hear it, or you're just curious about something, let Mr. Sharp or me know so we can answer those questions. Will you do that?
Yes, sir.
Excellent. Mr. Abate, when you're ready.
Thank you, Judge. If you'll do the best you can, raise your right hand. If you solemnly swear and affirm the testimony you're about to give in the matters pending before this court with the truth, the whole truth, and nothing but the truth, sir.
Yes, sir.
Put your hand down. And could you state your true, correct, and legal name for the record?
Dave McKinnon.
And Mr. McKinnon, are you at this time taking under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take regularly or on a daily basis that you haven't taken today that would affect your ability to understand why you're here today?
No, sir.
And how old are you, sir, and how far have you gone to school?
21. I graduated
Where'd you graduate from?
by Christian Academy.
Where's that?
It's school in Forest Park.
And are you able to read, write, and understand the English language?
Yes, sir.
And do you understand that you're charged with the following offenses in indictment number 22 SC 181907, count 1 murder, count 2 felony murder, count 3 aggravated assault, and count 4 possession of a firearm under the commission of a felony?
Yes, sir.
And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled guilty, or if you pled not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And have you had enough time and the opportunity to speak with Mr. Shart about the rights that you were waiving here today by entering a guilty plea?
Yes, sir.
Okay. And are you satisfied with the services that Mr. Shart has provided?
Yes, sir.
And Mr. Shart, do you waive formal reading of the indictment?
So waived.
And do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
And Mr. McKinnon, has your attorney, Mr. Shart, advised you of the minimum maximum sentence for each charge that you're pleading guilty to?
Yes, sir.
And did he advise you that count 1 murder is being reduced to voluntary manslaughter under OCGA 16-5-2, where the minimum is 1 year, the maximum is 20 years?
Yes, sir.
And did he advise you count 2, which is felony murder, upon your plea of to count 1 voluntary manslaughter would vacate by operation of law?
Yes, sir.
And did he advise you that count 3 aggravated assault, the minimum is 1 year, the maximum is 20 years, but that count would merge with count 1, the voluntary manslaughter?
Yes, sir.
And lastly, did he advise you that count 4, which is possession of a firearm during the commission of a felony, is 5 years, but it can, and it must run consecutive, but it can be suspended, probated, or served in prison?
Yes, sir.
And do you understand, Mr. McKinnon, that this is a negotiated plea of guilty, which means the state and your counsel will recommend a sentence to the court, but the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively, which means one after another?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal court, sir?
Yes, sir.
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation regardless of any advice given to you by your attorney or anyone else, sir?
Yes, sir.
Okay. And do you understand that you waive any and all defenses by entering a plea of guilty here today?
Yes, sir.
And do you understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you are unable to afford an attorney at the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to appeal if convicted of these charges after trial. You understand that you're giving up or waiving all of these rights by entering a guilty plea here today?
Yes, sir.
And Mr. McKinnon, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty?
Yes, sir.
How do you plead to count 1, which is murder being reduced to voluntary manslaughter under OCGA 16-5-2 and indictment number 22 SC 181907?
Yes, sir.
How do you plead? Guilty or not guilty?
Guilty.
And how do you plead to count 2, felony murder?
Guilty.
How do you plead to count 3, aggravated assault?
Guilty.
And the last count 4, possession of firearm in the commission of a felony? How do you plead?
Guilty.
And may I just have one moment?
Yes.
Guilty to count 2, okay, which is felony murder, but by operation of law, since you pled guilty to voluntary manslaughter on count 1, that sentence for felony murder is going to be vacated. So you're not going to receive a sentence for that. Okay? Okay.
We good?
Yep. Yes, sir.
And is this a guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes, sir.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes, sir.
And lastly, do you understand that you have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea?
Say that over.
You have only 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea. Did Mr. Shard explain to you what a habeas corpus petition was?
So if you want to challenge this guilty plea and say somehow you were tricked or forced into pleading guilty, you only have 4 years from today's date to file a habeas corpus petition. Okay.
You understand?
Yes, sir.
Your Honor, had this case proceeded to trial, the state would have proved beyond a reasonable doubt that on August 30th.
Let me pause you for 1 second. You're welcome to go into as much detail as you did with Mr. Russell. Mr. Shart, I want us to make sure we cover enough that your client is comfortable there's a factual basis based on your conversations with him. I'm also happy to incorporate into this record the transcript from Mr. Russell's plea, where Mr. Abate went into great detail of the facts and circumstances resulting in Mr. Jenkins being shot at least 4 times, including fatally in the leg.
Right, and I will say, Your Honor, that I've reviewed the video many times and had many conversations with Mr. McKinnon about what the evidence is and what the accusations are. So whatever pleases the court, he is fully aware of what he is accused of.
Okay, and what the state believes it could show.
Right.
Okay, so I want you to keep going, but you're welcome to streamline it a bit, given what you've already shared with me, such that you think you're making out a sufficient factual basis. I find that there is, based on what you told me, but that wasn't in front of Mr. McKinnon.
Beyond, the state would have been able to prove beyond a reasonable doubt that on the 30th of August 2021, around 6:44 p.m., the defendant, Mr. McKinnon, was with his co-defendant, Latron Russell, at 617 Joseph E. Boone Boulevard, which is the L&L grocery store. While hanging out at that grocery store, Mr. McKinnon came into possession of a handgun, which was given to him by his cousin, Juantavius Aldridge. After being given that handgun, he can be seen on the video surveillance with Mr. Russell to go in front of the store, where Mr. Jenkins exits the store. They all converse for a few minutes. After some time on the video, as the court is aware, Mr. Russell then attempts to rob Mr. Jenkins by force. At that point, Mr. McKinnon pulls out a firearm, and he can be seen following very closely to the struggle for the bag into the street and out of the camera view. At that point, it would be the testimony of individuals from around the store, as well as from Atlanta police officers, heard a number of shots, and the defendants can be seen running from the area of the crime.
Do you know from what you've heard and seen where Mr. Aldridge, not where did he go, but he would be moving in a different way? You're saying that Mr. McKinnon and Mr. Russell are seen running away. Do people say Mr. Aldridge also got out of there, or?
Mr. Aldridge remained on scene.
Okay.
While on scene, the detectives attempted to, or the police officers who initially arrived attempted to speak with him, at which point he said, I didn't see anything. I didn't don't know anything. There's a full investigation where Mr. McKinnon is identified by his manager at the Kroger Distribution Center as the person that can be seen in the video with the gun, wearing the red Crocs. He is arrest warrants are taken out for his arrest, and he is arrested on March 28th of 2022 by the Fugitive Task Force at the Trestle Tree apartment complex, which is off of Constitution Drive, Your Honor.
Less eventful arrest than Mr. Russell's?
It is less eventful in the sense that he was arrested coming back, or I believe that's the home of his either girlfriend or fiance. I know it's the mother of his child. Upon his arrest, there is a gun in the car in which he is arrested in. And at the time of his arrest, he was actually on bond for a possession of cocaine case out of Cobb County, which he has since his arrest subsequently pled guilty to.
Okay.
And nothing further from the state.
All right. Before we hear from Ms. Jenkins, Ms. Jackson, do you have any criminal history information on Mr. McKinnon?
Yes, Your Honor. The defendant has 5 cycles. The defendant's last arrest was August the 9th, 2021 in Cobb County for possession of cocaine and possession of a firearm during commission of a felony. The defendant appeared to be on probation in Cobb County for possession of cocaine. That disposition date was June the 26th, 2022. My term is for 2 years. Also, it appears to be an outstanding hold out of Marietta, Georgia, for a failure to appear. The date on that warrant was November the 29th, 2021. Nothing in addition, Your Honor.
Thank you. And Ms. Tucson, do you have any probation information about Mr. McKinnon?
Good morning. He is currently on probation. He has a year, 5 months, 28 days in Cobb County for that she mentioned.
Got it. So that clock is running, even though Mr. McKinnon is stuck in custody now, he is getting credit on that probated sentence out of Cobb.
Correct, because it's indicated here that he is in custody in Fulton.
Okay, he is. All right. Thank you so much.
No problem.
Ms. Jenkins, you've been very patient. Now is the time. If there is more you'd like to share with me beyond what you've shared in the past when we talked about bond and other things, I'd be happy to hear from you.
Yes. Can you hear me?
Yes, ma'am.
Can you hear me? Okay.
Yes, ma'am.
Okay. You know, this whole thing has upset me and turned my life upside down. No matter what happens, no, it can't bring Marquise back. But I feel they should serve the fullest terms for taking my grandson's life for nothing. For nothing. You shot him 4 times for nothing. And that right there is a disgrace. And I'm just disgusted with the whole episode of it. Marquise meant everything to me. He was his father, my son, died 6 years before he died. He had a heart attack. And Marquise was the only thing really that I had left. And you took him for nothing. I hope you live with this for the rest of your lives. Both of you. I can't accept your apologies. I don't care how sorry you are. It doesn't matter to me. That's my feelings. It doesn't matter. All I can think about is how you took my grandson's life for nothing and you didn't even know him. He didn't know you. You know that. You people know that. You didn't know my grandson. You just wanted his possessions. And then after you killed him, you still didn't take him. So that shows how disgusting this whole thing was and meaningless. You just evil people. You're evil. And may God have mercy on your souls. That's all I have to say.
All right, Ms. Jenkins, thank you for being patient and staying on for this. You're welcome to stay on further. I appreciate your comments. Mr. Sharp.
Thank you, Your Honor. May it please the court. It's clear to me that nothing that is said here today will satisfy everyone, and that's completely understandable. I will say that it's not lost on me as a defense attorney. It's not lost on my client that everything that happened, it wasn't worth it. It was senseless. There's obviously a major problem with the value we put on life, with guns. Mr. McKinnon, under the law, was not a convicted felon at the time. He was allowed under the law to possess a gun, but that doesn't mean that we can all go through life living by the gun, even if it's legally possessed, and just devaluing each other's lives. The sad thing is, I think if I had a time machine, which I often wish I had as a defense attorney, Mr. McKinnon would probably, well, not probably, I'm sure he would want to hop in that time machine with a more proper valuation of his role in society, a more proper valuation of Mr. Jenkins' life, a more proper valuation of his own life. The reality, Your Honor, is at the time of this incident, Mr. McKinnon, who did not have it easy growing up, but at the time of this incident, he was really on the precipice of living a normal life. He had a job at the Kroger distribution center. He has a son. He had another job where he was a caretaker for cash. So he had legal ways to make money, and it's just really unfortunate and short-sighted. His mother's here today, and other people in his support, his sister. You know, it's tough to explain years, decades, felony murder. It's tough to explain all these different legal concepts to people. And so it's just led to a lot of stress and confusion and regret. But the David I know that he would do anything to go back and do things differently that day. The David I know is the David that's been soft-spoken and saying yes, sir, in court here today. And David, from the beginning, and we appreciate the willingness of the state to deal with us. David, from the beginning, has expressed a desire to me. My task and role in this case from David and his family has always been to get the best possible outcome without going to trial. And he's been, from the beginning, been willing to accept responsibility in this. So it's a very unfortunate day, but we understand why we're here. We're asking that Your Honor would accept this guilty plea. I've explained the parole ramifications and all of those matters with him. And so he understands that it's important, not guaranteed, but it's important to have the possibility of parole. And he understands that one of the aspects of parole and one of the considerations of the parole board will likely be his behavior going forward. So I've stressed that to him, and we know it won't be easy, but we're hopeful that better things are ahead. And of course, you know, my thoughts and our thoughts are with Mr. Jenkins as well.
All right. Mr. McKinnon, you can share now if there's anything you want to share. You don't have to say anything at all, but we've reached the point where you've got a right to add what you want to add to the situation if there is something out there. You're good? Okay. Mr. Abate, you probably said it and I didn't write it down, but my recollection, actually, I think from before we started the other plea, was that the negotiated resolution here is 20 years to serve on count 1 plus 5 years to serve on count 4?
That's correct, John.
Okay, got it. Mr. McKinnon, I find that there is a factual basis for your plea. I've heard a bunch about the case way back from the bond hearing, if you remember that far back. And then coincidentally, the case was assigned to me. And I've heard more today as to what the state could prove. And I find that if the state did prove all that, a jury could find you guilty of murder. but you're being given, it may not seem like an opportunity because all the numbers we're talking about are big numbers, but you're being given the opportunity to plead to voluntary manslaughter. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to enter this plea. You're not excited about it, but no one has said, you better do this or I'm gonna hurt your family or take your kid away or anything like that. Is that a fair statement? No one's forced you to do this?
No one did.
No one did. So you're entering this. You've decided after consulting with Mr. Sharp that this is the best way forward for you.
Yes, sir.
Okay. And a knowing plea simply means that after we've had the discussion we've been having, you understand everything that's been discussed. Is there anything that we've talked about that you've got any questions about?
No, sir.
Okay. Mr. McKinnon, do you authorize my staff to sign the indictment indicating your guilty plea?
Sir.
Mr. Sharp, can we sign on your behalf?
Yes.
And Mr. Abate?
Yes, Your Honor.
Mr. McKinnon, I'm going to follow the negotiated resolution. In some ways, this seems like letting you off easy for having taken a life, but in other ways, 25 years is such a long time. You haven't been alive for 25 years. And so we start to play games when we say, oh, you need 30 years for this really to matter. Once you get past a certain number, you're just serving time. And this is going to, if you're going to learn anything from this, you're going to learn it under this sentence. And had you gone to trial and been found guilty of murder and been sentenced to life, not life without parole, which you're eligible for, but life, then you'd do 30 years before they'd even think about parole. Here, they might think about parole before then. If, as Mr. Sharp said, you make a different set of choices while you're in custody. And that's not the easiest place to make smart decisions because you're not surrounded by a lot of role models. But you can become one. You can decide that you want to get out sooner. And you demonstrate that to the folks in the Department of Corrections and Pardons and Paroles by making decisions that are real different from the kind you made on August 30th of last year. Easy for me to say all this. The hard part is you deciding how you're going to manage it. But that is for you to do. I feel Ms. Jenkins's pain. I understand and agree when she describes this as senseless. I'm not going to ascribe evil and good and this and that because there are so many societal failings that are behind the fact that Mr. Jenkins had his little bag with what was in it, and you had a gun, and Mr. Aldrich had a gun and was in a wheelchair, and there's more blame to go around than we could spread. But the fact is, for no good reason, Mr. Jenkins is gone, not for 20 years or 25 years, but forever. And Ms. Jenkins won't get to see him again. Your family will get to interact with you while you're in custody and then see you and hold you when you get out. And that's an advantage that Mr. Jenkins will never have. So, Mr. McKinnon, I'm going to sentence you on count 1, which has been reduced to voluntary manslaughter to 20 years to serve. Count 2 is vacated by operation of law. Count 3 merges into count 1. Count 4 has to be consecutive and is 5 years. So that will be a total of 25 years to serve. You will get credit for all the time you've been in. Sounds like you were arrested in March. So 3 to 12 is 9 months. You've already done about a little less than 9 months. That'll be credited to your sentence. As Mr. Sharp has mentioned, these are parole eligible offenses. So at some point you will be considered for early release if Pardons and Paroles thinks that that makes sense. It's not a decision I make or Mr. Sharp makes or the prosecutor makes. Mr. Abate, anything else in connection with Mr. McKinnon's case?
I got it.
Mr. Sharp?
No, Your Honor.
Okay. Thank you, everyone.
Thank
Mr. Sharp, quick question for you, unrelated to this case. Did you sign up for the C3 program?
Yes.
Have you received cases? 2. Good. Okay. So far it's working.
Yes.
All right. We had a little hiccup with GPDC and they scooped up a whole bunch of cases without necessarily the person power to do it. And so some of those have slid back to us and we'll be pushing more out. I just want to make sure you were in that rotation.
Just, can I ask a question?
You can. That's what we're talking about right now.
YSL case still,
Yeah, I don't know that that is on that list because I don't know that that judge said, I need help with that. But I hosted a little Zoom forum, and one of the questions was, well, if I get that, can I say no? And the answer is you can say no to any assignment. You don't have to take anything. There were some people who were saying, how do I get that? And that would be either good luck or bad luck, depending on your perspective. Well, then you can't. Yeah.
I was just kind of wondering what it says.
Yeah, I don't know. I also know there are a couple fugitives, although I signed something that may make someone not a fugitive soon. And so they'll need lawyers as well, unless they fall into the category of I can afford Brian Steele and Bruce Harvey and whomever.
All right.
Who they're taking. Thank you for your work on this case.
Thank you.
Let's go back on the record briefly for Mr. Christopher. Mr. Christopher, you come back up to the table, please. Mr. Hand, you're still here? You are. Mr. Abate, thank you for your work with Ms. Clark and Mr. Shart on this matter. And regrettably, I will not see you next week.
Thank you, Judge.
Am I going to be seeing something from you on the Cook matter?
Yes, today.
Okay, there's not I mean, I think you have 30 days or whatever it is, but I had heard, I had read that something would be coming.
Yeah.
Okay, all right. Thanks.
No problem. Judge Emerson's still set to come 12, correct?
Yes, and that was brought up yesterday when Mr. Hand and Ms. Wood were here just going over that. The current plan is for that to be called in the order it's published. So Ryan Williams is up first, which is what these folks wanted to know because they've got the case right behind it. So I'm sure they'll be consulting with Ms. Feely and with you as to how that's shaking out.
It's ready and it won't be a plea.
Okay. And I'm here for that. I'm just going to be in 9J dealing with a Georgia power truck that ran over someone's foot. All right. Thanks, everyone. Ms. Rivers, we are going to pivot back to Mr. Christopher's case, which is 21 SC 177401. And I am at this point not going to enforce the plea agreement. My processing of it was along the lines of what you heard me say about fraudulent inducement. There's of course no Georgia case law on the notion of applying contract principles to a plea, and then it turns out that one of the two sides agreed to it based on a misrepresentation that was knowingly false, either by the lawyer or someone that the lawyer was representing. But there is plenty of case law about that, and I've been reading it, and whether it's federal or in other state jurisdictions that say that it defeats the policy purpose of requiring both sides to adhere to a plea agreement if someone obtains a plea agreement in a way that is fraudulent. Now, I'm not reaching that as a final conclusion because all I've heard is what Mr. Hand says, Ms. Newborn says. But it is a sufficient change in circumstances, and the nature of the change of circumstances, I think, would support a finding of fraud in the inducement, in other words, a fraudulently induced plea agreement. And I also want to be clear, I've said it before, I put none of this at Ms. Wood's feet. I'm not attributing this to Ms. Wood knowingly misrepresenting anything to Mr. Hand. What you all need to do, because Mr. Christopher's case is out ahead of Castillo and Cano, which is going to be our only remaining case, assuming the Sexton plea goes forward, is you all need to be ready to go on Monday morning. And what I'd like to do is hear from Ms. Newborn outside the presence of a jury, obviously, in other words, before jury selection. What I don't want to do is wait till we picked a jury and then Ms. Newborn testifies and then Ms. Wood is in a position to say, hey, we've all heard what she had to say, and you can't credit this claim of a false alibi, et cetera. I'm not in a position to evaluate Ms. Newborn's credibility based on the current exchange. But I need to see if there is a plea that ought to be enforced. And so my thought is that unless the case otherwise resolves, we convene at 9 on Monday, and Ms. Newborn needs to be here. She won't need to stay all day, but I'll need to hear from her under oath. Both sides can ask her some questions, doesn't need to be all that extensive. But that may frame the defense thinking about whether they then want to pick a jury or not. And it will inform me as to whether I will, and I'll ultimately enter a written order because this is an appealable issue down the road. If ultimately there's a trial because Mr. Christopher said, well, I would have taken this other deal and you took this deal away from me. And so I want to preserve his right to challenge that if the way it plays out is there is no plea, there's a trial, and there's a conviction. He ought to be able to pursue that. So I think you said there were some motions in limine as well. We can work through those on Monday. But please, if you're not resolving the case short of trial, get voir dire to Ms. Nelson today. And then we'll need Ms. Newborn here at 9. We'll start with her so then she can leave. You can let her know she won't be here all day. And then after I've heard from her and you've had a chance to examine her, we can talk about jury selection and motions in limine. And at least one of the motions in limine, if we run out of time before the jurors get here, it doesn't sound like that ruling you need in order to pick a jury. And so once jury selection is over, we could finalize our discussion about the motions in limine.
Yes, sir.
That is my proposal. Concerns about that, Mr. Hand?
Judge, I don't have any.
All right. Ms. Wood, I know it's contrary to what you have moved for, but your motion is conditionally or provisionally denied based on Mr. Hand as an officer of the court sharing what he shared, my review of the text messages as evidence that there is something there. Is it enough to rise the level of fraudulent inducement? The texts alone are not. They just happen to be consistent with some of what Mr. Hand shared. But like I said, I think we all need to, since Ms. Newborn has well within her rights declined to speak with you and your investigator, we all need to hear a little bit more from Ms. Newborn.
Yes, Judge, I understand. And I will be filing an additional motion in limine based on some new evidence I received at 6:41 this morning.
Okay. I will look for that. Mr. Christopher, the most important thing you can do between now and Monday morning is have no contact with Ms. Newborn. You can ask a question in a minute. Let me just tell you what I mean. Ms. Wood can reach out. Her investigator can reach out. If there is evidence brought to my attention that you tried to contact Ms. Newborn, you called her, you texted her, you put something online that is just you saying things about Ms. Newborn. I can't believe she's doing me like this. She's a liar. She changed her story. And I see that. I'll see you Monday morning, but you will not have a bond anymore. You will be in trial the rest of the time while in custody. Okay? Just is that serious? I just need you and Ms. Newborn not to overlap. If Ms. Newborn is reaching out to you, don't respond, but save that, because that's something you lawyer is really, really going to want to use. Look at this. She's texting me over the weekend saying, I'm so sorry. I felt pressure, whatever that is, but you cannot respond. I don't mean for this to be a trap. If she reaches out to you, you just don't respond, but you get it to Ms. Wood.
Yes, sir.
Okay?
Yes, sir.
You had a question. I'm happy to field your question. Ask Ms. Wood first, but I'm happy to. You're good?
Yeah.
Okay. Ms. Wood, anything else?
No, Your Honor.
All right. So Mr. Christopher, stay in touch with Ms. Wood, but unless something radically changes, you should be here 9 a.m. on Monday, and we'll work through these issues and then pick a jury if the case doesn't otherwise resolve.
Yes, Your Honor.
Okay? Thank you.
Thank you, Judge.
You bet.
Thank you, Judge.
Okay.
You bet.
Which
It's up to you.
is the next plea gonna take a while?
One of you is Mr. Hakeem.
Can I just speak with you after?
I have one more plea to take. Sorry. We'll still talk.
I'll just wait.
That's fine.
You'll be here next week, Mr. Hand.
Yes, Judge.
Okay,
Yeah, I'll be here, Judge.
okay. All right. Do you have a new destination?
I do, Judge.
Just not something you can share?
Not yet, Judge.
Okay, but you will
Yes.
share?
Yeah.
Okay, all right. Are you ready for Mr. Sexton?
Ready, Judge.
How do we say his last name?
I see sexy on.
Sexton? Like the I's not there. Sexton. All right, let's bring Mr. Sexton out, please. Ms. Rivers, you ready?
Yes, I am.
This is position 25 from our trial calendar, State versus Rodriguez Sexton, 22 SC 182239. Good morning, Mr. Sexton.
Good morning, Your Honor.
Mr. Sexton, Ms. Wood tells me that you are prepared to enter a plea in your case. Is that correct?
Yes.
Okay. The way that works is that Mr. Hand in a moment is going to put you under oath, and then he's going to ask you a bunch of questions about your rights, things that Ms. Wood has already discussed with you. And he's going to make a recommendation. Is this a negotiated or a non-negotiated plea?
Non-negotiated.
Non-negotiated. So then Mr. Hand's going to make a recommended sentence. I'll learn a little bit about your criminal history if you have one. Folks will tell me about that. And then I'll hear from Ms. Wood, and she's going to tell me more, maybe a different perspective. And then she'll make her recommendation. And finally, I'll hear from you if there's anything you want to add. And then I'll let you know what I'm going to do. I'm not bound by either recommendation, but they often serve as good goalposts or markers that the state is here and the defense is there. I could go lower, maybe. I don't know. It depends on these charges than what your lawyer is asking for. And depending on what the state's asking for, I could go higher based on what I hear. But I'm certainly guided by what I hear from both. Do you understand that?
Yes, sir.
Okay. It's real important that if at any point during our conversation you don't understand something or you can't hear what's going on or you just have a question about anything, that you ask that question or you let us know you're confused. Will you do that?
Yes, sir.
All right, Mr. Hand.
Yes, Judge. Before we begin, Judge, I do want to notify the court that the state's recommendation includes 2 downgrades. So count 1 would be downgraded to simply robbery under OCGA 16-8-40. Count 2 would be downgraded to home invasion in the 2nd degree, not first.
Okay, hold on, let me pull up the indictment then, because the calendar has things listed in a different order.
Okay.
Okay, no, count 2 is aggravated assault. So count 3 is home invasion, and that's being reduced to 2nd degree.
Yes, sir.
Okay, same statute?
Yes. Yeah.
Okay.
Just a different subsection, subsection C instead of B.
Okay, got it, 2nd degree. Okay,
And the remaining counts will be the same, Judge.
thank you.
All right. Mr. Sexton, if you could for me, raise your right hand so I can see it. Do you swear or affirm that the statements and testimony that you're about to give the court are the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can lower your hand for me. Please state your true and correct name for the court.
Rodriguez Raphael Sexton.
Mr. Sexton, are you currently taking or under the influence of any medicine, drugs, or alcohol?
No, sir.
Mr. Sexton, I'm sorry to interrupt. Do you mind removing your mask while we have the conversation? If you're all right with that, it'll be easier to hear you. Great. You all right with that, Ms. Wood? Okay.
Are there any medicines that you would normally take that you have not taken today or been given?
No, sir.
Okay. How old are you, Mr. Sexton?
21.
And how far have you gone in school?
I got my GED.
Is it fair to state that you can read, write, and understand the English language?
Yes, sir.
Okay. Do you understand that you have been charged with the following offenses today? Those are robbery, home invasion in the second degree, possession of a firearm during the commission of a felony, aggravated assault, and false imprisonment.
Yes, sir.
And that's indictment number 22 SC 182-239.
Right, so he's just telling you that's what the charges were originally. Okay, do you understand that?
Yes.
Do you understand that you have the right to plead guilty or not guilty to these charges?
Yes, sir.
Do you understand that if you plead not guilty or remain silent or refuse to enter a plea at all, that you have that the state is required to prove these charges against you at a jury trial?
Yes, sir.
Have you had an opportunity to review your rights with your attorney today?
Yes, sir.
Have you had enough time to speak with your lawyer about all of the facts and circumstances in your case, including those surrounding each charge today?
Yes, sir.
Would you like more time to speak with your lawyer?
No, sir.
Are you satisfied with your lawyer's services?
Yes, sir.
Attorney Wood, would you waive a formal reading of the indictment for purposes of today's plea?
So waived.
And do you waive any and all defects in the indictment for purposes of today's plea as well?
So waived.
Judge, the state will announce that there's no outstanding warrants that we're aware of related to these charges. Mr. Sexton, do you understand that the minimum and maximum sentence for each charge today are as follows? For robbery, it's 1 year to 20 years imprisonment. For home invasion in the second degree, it's 5 to 20 years imprisonment. There's also a fine of $100,000. For count 3, possession of a firearm during the commission of a felony.
So count 3 is actually home invasion. Count 2 is aggravated assault, which is 1 to 20.
That's correct, Judge. I'm sorry, I'm reading them in a different order.
That's okay.
I'll just name the charge.
There you go.
For possession of firearm during the commission of a felony, the minimum and maximum is 5 years consecutive to the underlying crime. For aggravated assault is 1 year to 20 years, and for false imprisonment is 1 to 10 years. Is that your understanding of the minimum and maximums?
Yes, sir.
Okay. Do you understand that you are pleading guilty today in what's called a non-negotiated plea, and that the state may recommend a sentence to the court even without you having agreed to it in advance?
Yes, sir.
Are you aware that the state's offer is 15 years to serve 8 with the balance of that probated and restitution for items that were taken during the incident?
Yes, sir.
Have you discussed this offer with your attorney?
Yes, sir.
And do you understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state and up to the maximum on each charge?
Yes, sir.
Do you understand that if you enter a non-negotiated plea, you do not have a right to withdraw that plea once the court enters its sentence?
Yes, sir.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that if you are currently on probation or parole, that probation or parole may be revoked based on you entering a guilty plea today?
Yes, sir.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit, that being municipal, county, state, or federal law?
Yes, sir.
I'm sorry, Mr. Sexton, I need to hear you say yes and not just.
Yes, sir.
Court reporter. Do you understand that if you are placed on probation, you must follow any and all special conditions of that probation?
Yes, sir.
Do you understand that if you fail to follow all of the special conditions of your probation, then you will be subject to revocation of that probation for the balance of your sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Mr. Sexton, are you a United States citizen?
Yes, sir.
Okay. Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm at all?
Yes, sir.
Do you understand that doing so will result in new criminal charges for which you will face a sentence between 1 and 10 years?
Yes, sir.
Do you understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses.
Yes, sir.
Do you understand that by pleading guilty, you are giving up the following rights? Those are a right to a trial by jury, the right to remain silent, the right to confront witnesses against you, the right to the assistance of counsel, the right to the presumption of innocence, and the right to appeal if convicted of these charges at a jury trial.
Yes, sir.
Is it your decision to waive these rights, which means to not use them and enter a guilty plea today?
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter into a guilty plea?
No, sir.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges of robbery, home invasion in the second degree, possession of a firearm during the commission of a crime, aggravated assault, and false imprisonment?
Guilty.
Do you plead, is this guilty plea freely and voluntarily given with the full knowledge of the charges against you?
Yes, it is.
Do you understand that you only have a limited right to appeal this guilty plea conviction?
Yeah.
Do you understand that if you wish to challenge the voluntariness of this guilty plea, you must do so by filing a document that's called a habeas corpus petition?
Yes, sir.
And do you understand that for a felony charge, you only have 4 years from today to file this document that's called a habeas corpus petition?
Yes, sir.
And Judge, at this time, the state will give a factual basis for the plea today.
All right.
Judge, were this to proceed to trial, the state would show beyond a reasonable doubt that on July 11, 2021, approximately between midnight and 1 a.m., Dwayne Evans, who was living at 3462 Parkview Place, apartment 6 in Hateville, Georgia, and he was at that location. He was robbed at gunpoint by 3 individuals in his home. That location is also in Fulton County. Hateville police received a 911 call for this robbery. They responded to that location. When on scene, Mr. Evans spoke to the police, specifically Officer Martinez, and told him that a female named Yana had set him up to be robbed that evening. He described her for the police, stated she was a Black female, approximately 5'8" in height. She was wearing a bodysuit at the time. He could not provide at that moment her phone number or her Instagram account because his phone had been taken during the robbery, Judge. However, he did describe what happened. He had only known Miss Yana for about 3 months. They had been hooking up on and off. One evening, this evening, July 11th, she messaged him on Instagram, which is how they communicated, and asked him if she could come hang out. She specifically asked him if his roommate was home, and he said no, he wouldn't be home at the moment. He noticed that she was dropped off to his house in a white car. He didn't know what type, make or model, but this is what he reported to the police. She came inside, he closed the door behind him. They spoke for a little bit, and then she asked to go to his bedroom, which is another part of the apartment. Once in the bedroom, she was on her phone, he noticed, but they were still talking and listening to music. At some point, she asked to go get water from the kitchen. She left for about a couple minutes, and then Mr. Evans states 2 Black males entered the room. He doesn't know how they got into the unit, his apartment. They both had guns. They pointed them at him, told him to not move. At that point, Mr. Evans was seated on his bed against the wall. He said that both individuals pointed a gun at his head while they took his stuff. They told him to give him everything. The items that they took specifically, Judge, were his PlayStation 4, which was worth about $350, his camouflage controller, worth about $60, an iPhone 10, worth about $400.
I love you. See, like, okay.
A fanny pack that contained certain items, including a wallet, a driver's license of Mr. Evans, a social security card, $150 in cash, Apple headphones worth $119, an extra key to his house, and lastly, a red bag that he had savings in, which had about $400.
So that's the red cookie bag.
Yes.
I was waiting for you to tell me about the cookies that were taken, but it was a bag
It was a cookie bag
that had money in it.
that had money.
Okay.
Yeah. Those items, using those values, Judge, come up to about $14.79. After taking the items, he said the individuals told him that if he said anything, they would come back and kill him. Obviously, this worried him because he knew his spare key had also been taken in the process. At that point, he waited a couple minutes until he felt they were gone. He then left the location. He got in his car, not take his car or his car keys. He drove to his brother's house because he didn't have a phone to call police. He did not call it at his brother's location. They both returned to where the incident happened, which was his home, and called police from their Judge. And of course, police arrived and he gave that particular statement. On July 13th, Judge, a couple days later, Detective Gwynn was assigned to this case, and he came back to the location of Mr. Evans' home and got a written statement from him. He was also able to obtain more information. Specifically, Mr. Evans was able to log in online and find where his iPhone last pinged. The location of that last ping, Judge, was 6770 Buffington Road in Union City, Georgia. Detective Gwynn put that in Google and found that it was an apartment complex called the Park at Netherly Apartments. Additionally, on the victim's social media account, there was a photo that was posted from his phone. That photo was of both the later identified as Miss Adriana McBurrows, who was Yana, and then a photo, in that same photo was the defendant, Mr. Sexton.
So our co-defendant, who I think is a fugitive, that Ms. McBurrows is Yana, is the young lady with whom Mr. Evans had been spending time.
Yes, Judge.
Okay. And on Mr. Evans's Instagram account is a picture of Yana, you said, with Mr. Sexton?
Yes, Judge.
Okay.
Posted shortly after the robbery.
Right.
With that information, Judge, while also at the location on July 13th, Detective Gwynn reviewed surveillance cameras from the apartment complex. He was able to observe around the time that was stated by Mr. Evans, a white Honda with a sunroof pull up to the apartment complex. A young lady who matched the description that was given by Mr. Evans. She had a bodysuit on. She had two kind of Mickey Mouse pigtails. She exits the white Honda and she goes up to Mr. Evans' apartment, knocks on the door, he lets her in. Immediately thereafter, two Black males exit that same white Honda and they go up to the steps to the apartment to Mr. Evans and they wait. Shortly after, you see Ms. McBurrows, later identified as Ms. McBurrows, exit the house and let the two individuals in. Later, she comes out, she gets back into the white Honda, and then moments later, the two Black individuals, males, come running out of the apartment in a hurry, get in the white Honda, and then they exit the apartment complex. So it appeared to fit exactly what Mr. Evans thought had occurred that evening. The next day, Judge, on July 15, 2021, Detective Gwynn went to that address where the phone pinged, looking for that white Honda. He did locate a white Honda. Conveniently, the windshield on the front of that white Honda had a fracture of the glass right above the VIN number. So he could not obtain the VIN number because he couldn't see through it. However, he did ask the maintenance persons at that property to notify him if anyone comes back to that vehicle. Detective Gwynn gave him his card. 30 minutes later, he got a phone call, returned back to the location. Himself and another officer, Officer Cushing, still didn't observe anybody at the white Honda. So what they ended up doing was door knocking. One of the apartments that they knocked on was apartment 2703, which was occupied by Mr. Terrence McBurrows, who would later be termed as the father of Ms. Adriana McBurrows. He opened the door. Detective said, "Do you know someone named Yanni?" He said, "Yes, that's my daughter." And he identified her that way. That same photo that was found on the Instagram account was showed to him. He said, "Yes, that's my daughter." He asked him who the other individual was in the photo. He said that is her boyfriend. He identified him as Rodriguez, but did not know what his last name was at that time. From there, Detective Gwynn took the name Rodriguez, and he discovered that this Rodriguez guy had went to a Forest Park High School from conversations with Mr. McBurrows. And he went to that high school, photo, talked to office personnel, and they said, we know who that is, or here's someone who fits the description. From there, he got the name Rodriguez, Sexton, and also a date of birth. That was ran in a system where a previous arrest was found in Clayton County Jail. From there, a photo was obtained. One thing that was omitted, Judge, that I forgot to mention was during the description from Mr. Evans to Detective Gwynn, he stated that one of the individuals who robbed him had a tattoo on the side of his face near his eye. And so that was something that was also observed in the photo that he showed to school personnel, as well as Mr. McBurrows, Avriana's father, who identified him as Rodriguez. Judge, a search warrant was obtained, search warrant 3532, to the white Honda vehicle. It was signed by Hateville Municipal Court Judge. On July 16th, it was executed. That vehicle was searched. Various items found within that vehicle belonged to Ms. McBurrows, including mailing labels that had her name on it, a Visa debit card that had Avriana McBurrows on it as well, a food receipt that had her name on it. They also looked in the trunk. Within the trunk of that car, Judge, they found more photos that were photos of Ms. McBurrow and Mr. Sexton as well. Those photos were additionally used when Detective Gwynn eventually went to 5000 Ash Street. That address was obtained from the jail booking information that they obtained for Mr. Sexton when he was arrested in Clayton County.
None of Mr. Evans's stuff was found in the Honda, just Ms. McBurrow's belongings?
Correct, Judge.
Okay.
Yeah, correct. Well, I'm sorry. I apologize, Judge. There was a debit card found of Mr. Evans in the car.
In the Honda?
Yes. Judge.
Okay.
So from there, Judge, Detective Gwynn went to that address that he obtained from the records. Apologies. And he observed several folks outside of this location who, similarly to Mr. Sexton, had blonde tips on the ends of their hair. He approached an individual woman who was later identified as Cara Sexton and asked her who she was and if she knew Mr. Sexton. She told him that she was his aunt and that his mother was there, lived there as well, but she was at work. He showed them the photos that he had and said, "Do you know this person?" She said, "Yes, that's my nephew, Rodriguez Sexton." He additionally asked others there who also identified, including the grandmother, Joanne Tolan, who was also at the location. The detective at some point as well was able to get a phone number for Ms. McBurrows. He certainly called her father, Terrence McBurrows, and let them know that they would be taking out warrants for her arrest based on the events and for her to call him. Miss McBurrows eventually did call Detective Gwynn. She asked what was going on. He told her, "Hey, we're investigating this on robbery. You're a part of it. You need to come in and talk to me." She said, okay, she agreed to, but never showed up, Judge. So at this point, once Mr. Rodriguez was identified by his family members as being the person in the photos with Ms. McBurrows, a photo lineup was done, not for Ms. McBurrows, but for not for Mr. Sexton, but for Avriana McBurrows. That photo lineup positively, Mr. Evans positively identified Avriana McBurrows. One was Yes, Abraham McBurrows. One was not done for Mr. Sexton. The detective just showed him a photo of from the back of the trunk of that car. And he said, yes, that's one of the guys who robbed me. I know because at least one of the tattoos on his face, I remember. Based on all of that information, warrants were taken out for both of them for the charges that exist today. Suspect number 3 was never identified, nor never found. As you know, Ms. McBurrows remains not found. April 13th, 2022, police received information on where Mr. Sexton might be. They went to that location and apprehended him. Although Mr. Sexton, although we've not been able to find and arrest Ms. McBurrows, Mr. Sexton has reached out to her several times via jail calls. And so he's had constant communication with her, and we have a clip of that conversation as well for the court, if Your Honor would like to hear it, regarding any aggravation, considering this is a non-negotiated plea. But during that call, that call occurred in June 1st, 2022, before discovery was turned over to the defense about what occurred. And you can hear him talking about how he was possibly found. Part of it is he mentions an X, which refers to the number 10 as far as an iPhone. And he says, that X might have popped up when they were looking for it. And then Ms. McBurrows tells him, why are you talking about this? And so that is the clip. Additionally, Judge, we have footage, surveillance footage, if the court would like to see it as well, showing the entry into the apartment that night on July 11th. But that composes the factual basis.
That was some thorough police work by Hapeville PD. All right, thank you. Ms. Jackson, do you have any criminal history information for Mr. Sexton?
Yes, Your Honor, the defendant has 3 cycles. Defendant's last arrest was April the 20th, 2020 in Clayton County for possession of Schedule II controlled substance. That charge was null pros on June the 4th, 2020. They seem to have added giving false information to an officer, and he was convicted of that in 2020 out of Clayton County. That's the only misdemeanor conviction that he has listed in the GCIC, Your Honor.
Thank you. Ms. Wood.
Thank you, Judge. There's one fact I want to clarify because it's important for what I'm going to ask or tell the court. The third person was identified by Detective Quinn. He actually spoke with him. It was Edward Kalen Brown. The reason I'm highlighting that is because this individual's driving permit was found in the vehicle.
In the Honda also?
Yes, Judge, and the police report indicates that Brown was considered a possible suspect. And the reason that I highlight that for the court is because during the complaining witness, Mr. Evans' interview and his written statement, he tells Hapeville Police Department that the taller guy, so not Mr. Sexton, was the guy who seemed to be in control and in charge. And it's my belief that the co-defendant is actually who set this transaction up, and maybe the Mr. Brown was also a part of that, and then Mr. Sexton just got mixed up into it, Judge. So I did want to highlight that for the court.
Okay.
Judge, Mr. Sexton has family here in support today. His grandmother and his sister are present. They've been at a couple of his court dates, and I talk to them regularly, so I know that they are here for him. Judge, he's 21 years old. He's alive. Oh.
The person in blue who left is his mother?
Yes, Judge.
Okay, so we have grandmother and sister, and then a different generation mom who was here for a while.
Yes, Judge.
Okay.
He's 21. He's a lifelong Atlanta resident. He lives with his grandmother. He went through the 10th grade, and then he attended military school where he obtained his GED. He previously worked at Wendy's before this arrest. He is in a program at the jail right now, the New Beginnings program. He's been in there for the past 3 months, actually almost 4. And he tells me that he feels like he's really benefiting from that program. So Lord, Judge, we're asking that maybe, I think there's a way we can put on the sentencing sheet to recommend him for programs or whatnot with DOC. Because I feel like he would avail himself of that. Judge, we're asking for 15 serve 6. So we're pretty close with the state. We would ask for credit for time served. He's been in since April 13th of this year, so right at 234 days. And last, I would request a restitution hearing. I was not given any receipts or any proof of any of that, and I would also be disputing his ability to pay.
Okay.
Thank you, Judge.
You bet. Mr. Sexton, anything you want to add? You don't have to say anything at all, but this is an opportunity if you want to get something off your chest or share anything that you think I ought to be considering as I weigh. The two sides aren't all that far apart. Sometimes the state says we want 100 years and the defense attorney says, I want 1 year. It's a 99-year range. This is a 24-month range. So there's not a lot in there, but if there's something you think I should be thinking about, you should tell me.
Can I use my first offense?
Judge, he has a question about first offender.
Okay.
I know there's the Clayton County conviction.
But I think the Clayton County conviction was a misdemeanor,
Misdemeanor.
For false information. So you are, I believe, based on what we heard from Ms. Jackson, that you are eligible for first offender. I'll talk to you about that in a minute. Do you have any other questions?
Yes, sir.
Okay. All right. Well, let me start with the basics. First, I find there's a factual basis for your plea. Hateville must have either fewer cases or more resources than Atlanta Police Department because they nailed this one. And we need to find Ms. McBurney. So I find that if the state could prove all these things they said, the jury could find you guilty, at least as party to a crime, if not the ringleader, but you're not charged with being the ringleader. You're charged with being mixed up in this. Second, I find that your plea is knowing and voluntary. Knowing means you've understood the things we've talked about. Is that a fair statement?
Yes, sir.
No questions about anything anyone's talked about other than first offender?
No, sir.
Okay. Voluntary means no one's forcing you to enter this guilty plea. You may not be excited about it, but you've decided that is better than going to trial. Is that right?
Yes, sir.
Then I will accept your plea. I'm sentencing you pursuant to the Probation Options Management Act, which means the probated part of your sentence when you're on probation. If you have what we call a technical violation, something small, you miss an appointment or you have one positive for drugs or alcohol, you don't have to come back and see me. You'll work with probation on that. But if it's serious, you get arrested again, something like that, then you'll come back and see me. Do you authorize, Mr. Sexton, my staff to sign the indictment for you electronically, indicating that you have pled guilty?
Yes, sir.
Ms. Wood
Yes, Judge.
and Mr. Hand?
Yes, Judge.
All right. In terms of restitution, I won't put an amount in here. If the state wants to follow up with a hearing, we can do that. I don't know that they're going to find a PlayStation 4, $350, but anyway, they would need to demonstrate what they can in connection with a restitution amount. It's also, Mr. Sexton's not going to be in a position to pay restitution for a number of years. So the dollar amount we're talking about may end up not being worth the hearing, but we'll gladly have one if that's what the state wants to do. First offender is primarily an opportunity. It means that your criminal history won't show this felony conviction. And because the state was willing to reduce the armed robbery to robbery and the home invasion first degree to second degree, you are eligible for first offender. When you get out and you're on probation, if you're looking for work, you don't have to check the box that says I'm a felon. If you're wanting to go back to school to get a college degree, you don't have to tell anyone you're a convicted felon because you're not. You'll be a first offender. That's real helpful. And if you complete your sentence with no big hiccups, then it all stays to the side and you move forward as you are today, which is with no felony convictions. But it carries with it a risk. And in your case, it's a big risk. If probation doesn't go so well for you and you're hanging out with the wrong folks and you do anything along these lines, or just, it could be you get caught with some drugs or a gun, because you cannot have a gun while you're a first offender probationer. You get in trouble with the law and charges are brought. Not only do you have those new charges, but you could come back before me or some other judge for a revocation hearing. And if the judge revoked you, he or she could not only take away your probation, but say, you know what, you were a first offender, I'm taking that status away. And that judge could resentence you as if you had pled guilty, because you did. And just looking at these numbers here, your exposure is 60, 70, 75 years. So let's play out a hypothetical. Fast forward 8 years, you get arrested, you've got a gun. That's a charge already. A judge could say, you know what, Sexton, you said first offender, you're going to be a different guy. And here we are, you got a gun again. I'm going to resentence you on this case, the Dwayne Evans case, to 20 years to serve. Done. It's that easy. No trial, 20 years to serve. So first offender can bite you pretty hard if it's not something you can live up to. Do you feel like you understand the benefits of first offender?
Yes, sir.
You understand the risks of first offender?
Yes, sir.
Understanding the benefits and the risks, do you want to be sentenced as a first offender?
So if I don't do first offender, well,
It doesn't, I want to be clear, it does not change your sentence in any way. You don't get paroled sooner because it's first offender. Your sentence isn't shorter as first offender. It simply has that impact of, I don't have to check the box about being a felon. Versus if probation doesn't go well with you, not only could you have some probation revoked, but you could be resentenced and say, forget about that sentence McBurney gave you. Because you showed us you weren't ready for first offender, we'll give you 20 years on this case, plus your new charges.
no, I don't want it.
Okay. So that leaves us with a sentence. And the two sides aren't that far apart. This is one of those situations where everyone ought to say, thank goodness no one got hurt. I don't mean to suggest Mr. Evans wasn't traumatized by this and shook up and feared for his life when two guys come into his room, point guns at him and say, give us all your stuff. You and whether it was Mr. Brown or not, and in particular, Ms. McBurrows, are lucky that no one got shot, because what Mr. Evans could have done is like, yeah, let me get you my stuff. And he reaches in a drawer and comes out shooting. And then we don't have a Mr. Sexton anymore, or we don't have a Mr. Evans anymore because he didn't shoot well, or he's real slow in bringing it out. And frankly, my friend, even if you didn't have a gun and the other guy did, and he shot and killed Mr. Evans, that's your murder. And we'd be in here just like the gentleman before you. And we'd be talking about murder and sentences that aren't in numbers, but are in the word life. That's how serious this was. And it sounds like it was fairly well thought out. It went smoothly, other than that X. It might have been kind of hard to track you and Ms. McBurrows down. So it was serious stuff. I'm going to sentence you on, back to the counts, count one, which has been reduced to robbery, to 15 years to serve 7 with the balance on probation. Counts 2 and 3 will be that same sentence. Actually, let me do the math differently because it will be simpler this way. Counts 1, 2, 3, and 5 are all 10 years to serve 7 with the balance probated. Count 4 has to be consecutive, and it has to be 5 years, and I'll probate that. So the total sentence, so count 4 runs consecutive to count 1. The total sentence is 15 years to serve 7 years with the balance on probation. You'll get credit for the time you've been in custody. So that's coming up on 8 months. All those days will be credited towards your 7 years. These are parolable offenses. I'm not saying you will get paroled. You might, but at least you're eligible for it. If it were armed robbery, you do every day of the custodial part of your sentence. A special condition of your probation will be to stay away from Dwayne Evans, and another will be to stay away from your co-defendant, Avriana McBurrows. So no contact with Mr. Evans, no contact with Ms. McBurrows. Mr. Hand, anything else on behalf of the state?
No, Judge.
Not saying no to restitution. It's just if you want to move forward with that, you'll need to line up the proof you're going to have and we can have a hearing on that.
Will do, Judge.
Ms. Wood, anything else on behalf of Mr. Sexton?
No, Your Honor.
Mr. Sexton, any questions about that?
No, sir.
Okay. All right. Well, I want to thank your family for being here. I know they care about you. They aren't going to be able to see you directly for a little while, but hopefully when you get out, you will be more there for them than you have been recently. Okay. All right.
Thank you, Judge.
You're welcome. Thank you, Ms. Rivers. Ms. Tucson, hold on one second, Mr. Sexton. Ms. Tucson, I assume you don't need to give Mr. Sexton reporting instructions. He's going to not be plugging into probation right away and he'll work through that.
Yeah, they'll usually give them the reporting instructions once I, upload the final indictment. It's calculated in there, so they'll be expecting him.
Okay.
And use the data on his rap sheet.
Sounds good. Okay. So thank you, Ms. Tucson. Thank you, Ms. Jackson. You guys have a great weekend.
All right, you too.
Bye-bye.
Thank you, Judge. You too.